So on that note then, I'd like to begin proceedings with a pre-recorded presentation from Dame Vera Baird, the Interim Chair of the CCRC in England and Wales. As I said, given the widespread reported criticism of the CCRC over there in recent times, I thought carefully about whether Dame Vera was the person that we wanted to talk to us about the UK organisation. But as you will see, hopefully, she absolutely is. She has a history in law, policing and politics. She was the Victims Commissioner for England and Wales between 2019 and 2022, when she resigned, apparently when she thought the government at the time was not taking victims' interests seriously enough. So in her work, Dame Vera exhibits those very characteristics that I've just spoken about. Her presentation did not disappoint and provides an excellent starting point for us.
I'm Vera Baird, the Interim Chair of the England and Wales Criminal Cases Review Commission. I understand you're working toward getting a CCRC for Australia, and I have to say that's a project I support wholeheartedly. So the England and Wales CCRC has had its ups and downs, but in the almost 30 years of its existence has freed several hundred people from wrong convictions, and that makes me think that every democratic country should have such a body. It's an independent statutory body since 1997 to investigate alleged miscarriages of criminal justice when all appeals have been exhausted. If the CCRC finds new evidence or a new argument that casts doubt on the safety of a conviction or a sentence, it can refer the case back to the relevant appeal court. We have two levels of court, the magistrates and the Crown Court, which is jury trial, and some in between where you can elect either to stay in the magistrates or go for trial. I think you also have an intermediate court between the two, and actually we might have one of those quite soon. We tackle miscarriages of justice at the CCRC at both court levels and in the court martial for the military as well. The first point, I might have said before being chair that there are a lot of big cases to tackle which are alleged to be miscarriages. Why the magistrates court? It's small, but people are often represented there. People plead guilty thinking it doesn't matter, and then it comes up on a disclosure and barring response when they apply for a job and stops them working with children forever. Any crime can have that effect. Victims of modern slavery plead guilty because they can't do other than what their enslaver says, but equally couldn't resist him when he told them to deal drugs or rob or whatever it is to which they've pleaded guilty. So my first point for you is though it will be costlier, messier, and perhaps less intellectually stimulating in places, do ensure that your Criminal Cases Review Commission can tackle all levels of case because they're all in some way important to somebody. The second point, I said above that all appeals have to have been exhausted before people can come to us. 40% of our applications are from people who haven't appealed. The statute says that we may take a case that hasn't appealed in exceptional circumstances. None are set out, and so it's judgment and our internal guidance. But no legal aid, missed the time limit, got no lawyer are not ECs. Very, very little is an EC, but it takes us 10 to 12 hours of work per case to get the trial papers, to read the application, to go back to the solicitors, etc., to try and see if there are ECs. We have to do a kind of mini review. If, on the other hand, the person put in an appeal to the Court of Appeal on paper, and many do have to do it on paper these days anyway, if it didn't work, we could then spend 10 to 15 hours on a substantive review instead of just sending it back after a couple of months to a disappointed client, telling them to get on with an appeal. You must square your consciences about this question of exceptional circumstances, but I would not legislate to put that in. It takes 10 hours on 40% of the 1,600 cases we get every year when we could be tackling hard cases properly. Why the CCRC exists. In England and Wales, before it, once a case had failed in the Court of Appeal, there was only an application to the Home Secretary asking them to refer the case back to the courts. It was for indictable, that is, jury trial cases only. The process was reactive, what lawyers sent, not investigative, and it was run by officials in C3, a department of the Home Office, which runs the police. There were about 700 applications a year with about 4 referrals. Crucially, it placed the power to reopen convictions in the hands of a politician with more than perhaps a potential conflict of interest. The concerns about this came to a head in the 80s with a group of notorious miscarriage of justice cases related to a bombing campaign by the IRA connected to the troubles in Northern Ireland. 4 or more cases, but the Guildford 4, the Birmingham 6, Judith Ward were all alleged to have bombed pubs, and in Judith's case, a bus, and killed many people. The Maguire 7, which is the 4th miscarriage in this group, was said to be the family who made the bombs. Being terrorism related and highly political, there was intense pressure on the police to get arrests and convictions, and these cases involved serious police misconduct, prosecution non-disclosure, false confessions, deeply flawed forensic evidence. But applications to C3 were not actioned at all. Trust in the Court of Appeal was shaken. The Lord Chief Justice famously here said about the Birmingham 6 that the longer the appeal had continued, the surer he'd become of their guilt, only to have to release them a few months later. So that was a massive collapse in public confidence, and the government established a royal commission which concluded that it was imperative to have an independent body to tackle miscarriages of justice, and thus allowing politicians, as the Home Secretary is, to control referrals back to the court was not consistent with the separation of powers. So in 1995, the Criminal Appeal Act established the CCRC, marking a major constitutional shift in how miscarriages of justice are addressed in the UK. A list of key features that we have at the CCRC: independence. It operates independently from government, from courts, from police, to prosecution. It is an arm's length body of the Ministry of Justice, which runs the courts, but not the police. It is also independent of the applicant. But of course, we work closely with that person, and we've recently improved greatly how we do that. The second feature is it's accessible. Anyone can apply with or without a lawyer. It's free. The application form is easy read. There is no time limit, and people can come back as many times as they wish, as long as there is something new. Another feature is that it's safe in this way. If the CCRC makes a referral, the court has to hear it, and there's no risk of an applicant being made to serve some of their sentence again. That can happen if an applicant applies for leave to appeal to the court, which is denied because it's a poor appeal, they say, but that applicant perseveres to get an appeal through, the court can order in that case, when the appeal, if it is dismissed, that the person serves again part of the sentence they've served already. That's a massive deterrent to applications to appeal in the first place. And the belief that it might happen with us is a barrier to people coming to us, but it doesn't happen to us. Another feature, very key, is that we have investigative powers. We're not just a review body. We can compel public and private bodies to produce documents, preserve evidence, and deliver that evidence up. It happens very frequently with police forces, prosecutors, scientists, hospitals, schools, businesses. My third point about this feature is ensure this vital power. It's Section 17 in our statute, covers private as well as public bodies. Our CCRC only had power against public bodies for years, and it was very difficult. We couldn't get business material at all, and there was even an argument about, for instance, whether the BBC was public or private. The CCRC can also direct a police force to appoint police investigators to work on a case to the direction of ourselves, and we have a small internal investigations department which will help any case review manager with active investigations that need to be taken on. The case review managers are the people who investigate the cases. So my fourth point, investigation is often absolutely central. Ensure you have all the powers that you need. Another feature is our referral standard. We refer a case to the court if there is a real possibility that the conviction or sentence will be overturned because of fresh evidence or a new argument not heard at trial. That's criticised here as dependent on the court, but honestly, they are the decision makers. They could have legislated to make us the decision makers, and they didn't. We will always have to have regard to them. And I can tell you that there is no sense in the CCRC that there are a body of cases that would have been referred if the test had been different, for instance, that there was a miscarriage of justice. Mentioning, though, the Scots CCRC has exactly that test. A miscarriage of justice may have occurred, and it is in the interests of justice that a reference should be made. This is a smaller CCRC. It had 400 applications in the last 2 years compared to our 1,600 a year, but it does have a different test for you to consider. A further feature is the commissioners. These are the decision makers. So the case review managers do the preparation, make a recommendation, and then it's looked at by a commissioner to see whether they can decide accordingly or what. The first commissioners were the heroes, really, of the campaigns to free those Northern Irish people. There were journalists, solicitors, a forensic scientist who played a big role in some of these cases, explaining how people could confess to things they hadn't done under certain pressures. And then there were some irrelevant to that era, people like the head of a council, a former chief constable. 1/3 of our commissioners must be legally qualified. 2/3 have knowledge of or experience of the criminal justice system. Now, they were full-time with a full commitment to the CCRC, based at the office, working closely with the case review managers at the top, making the decision. Now, a few years ago, under a different government, the commissioners were changed to day-paid people. They have portfolio careers. So we have now a deputy coroner, a deputy judge, an ombudswoman, a working barrister. They're not all criminal lawyers. Commissioners are not employees. They are put there by royal appointment, and there is no leverage to manage them. They are focused elsewhere as well as with us. Quite clearly. And I mean, they're all excellent. I have no complaint about the people, but all they may have time to do is their minimum hours of decision making, and they vary. I mean, some will take overdue cases, which have been waiting for a decision, like, whether they're the right kind that they like or not, because they just need progressing. But some have preferences or expertise and want to do particular kinds of case. It's hard to organize them. So the time taken from a case review manager putting a completed case on the website and a commissioner taking it off to make a decision is 2 months. I repeat, our own commissioners are absolutely super, but you need to decide, do you want full-time people or part-time people? I don't think you'll have a royal appointment system. Don't. Employ them if possible, or bring in strong terms and conditions to get value for money and fast service. Let me just repeat once again, this is no criticism of the caliber of the people that we've got, but of the system. I think you should consider appointing lawyers and investigators primarily as commissioners, and perhaps some others. Our statute says that if the case review manager wants to refer a case to the Court of Appeal, it will need a committee of 3 commissioners to agree. And those cases are done extraordinarily well. I've been on committees myself, cross-referring, a mix of skills, debate. They're done very well indeed. The problem actually for us is probably reflect on this, not what we refer, but what we don't refer, and perhaps should. Now, only 1 commissioner is needed for a refusal to refer, and commissioners do not have to be lawyers, as I have said. We have ex-police, ex-solicitors, and a mixture of other people also as case review managers doing the work. Many excellent. The legacy, though, of having non-lawyer commissioners from those Northern Irish cases did reverberate onto our case review managers. On the first case review management since I became chair, which is only in June, but on the first recruitment exercise, I had to insist that knowledge or experience of the CJS, the criminal justice system, is an essential characteristic, not merely a desirable one. It's therefore possible, if you think about it, for a case to be refused referral when neither the case review manager is a lawyer or the commissioner is a lawyer. That's really a concern. I don't know if it's ever happened, but it's possible. You need to think what attributes you want if you have commissioners or whether you're going to have a whole different system. That's kind of my fifth point. The implications, as I'm asked to mention, for a CCRC for you are known far better to you than they are to me. You have a federal system with separate state and territory courts, each with its own criminal law and appellate processes. So you have to coordinate across multiple jurisdictions and have referral criteria and investigative powers all harmonised to ensure consistency. England and Wales is a cakewalk compared to that. And you'll have to decide what to do with your alternative routes forward. So C3 was just abolished. I think you have a petition for mercy to the Attorney General, and you have to be clear so that people who've suffered a wrongful conviction know where they should be going. Can I mention a few more systemic issues? Firstly, resource constraints, persistent budget pressures, and increasing workloads have led to big delays, backlogs, and inevitably, they have led also to risk. Big cases get attention and money, but the CCRC soon falls from prominence and can become a budgetary afterthought. In the UK, only 8% of applicants had legal assistance in the last year, down from 30% very recently, much harder for unrepresented applicants. There are some charities who also help applicants, and these days we work very much more closely with representatives and charities, but I mean, there aren't many of them. The complexity of cases advances. Forensic science is more complex, DNA in particular, massive digital evidence, phone masked evidence, falsehoods that can be created with AI, all increase the length of cases that our CRMs have got to do. And we are independent, but funding comes from the Ministry of Justice. So what I have thought, if we run out when we need a forensic report from Mr. Smith, who's been in custody 5 years and he shouldn't be, you have to build a budget margin in for such eventualities. My final kind of comment here is a cautious one. CCRCs are small organisations doing unique work. They are studiously independent and therefore separate from anybody else. They can easily start to think that the only people who know how to do this important job are them and become a little resistant to change. Our CCR casework system had never been inspected in almost 30 years. Now it's being inspected at my behest by the inspectors of the Crown Prosecution Service, who do similar casework in a sense, but from the other end, and it will continue to be regularly inspected. But add on to that position that in 90% of cases to the CCRC, there really is, scour as you may around everything, no reason to refer, and consider the case hardening that that might bring over time, even to the doughtiest fighter for justice. So in such an organisation, there is an exceptional need for continuous improvement mechanisms, regular review. Case worker morale has to be protected and supported, and of course, training on emerging challenges. So the England and Wales CCRC has had its ups and downs. I was asked to draw a map of what yours should look like, but that would be ambitious since I've only been the chair since June, and so I hope this is food for thought. It's had its ups and downs, but over its time, it has played a vital role in addressing miscarriages of justice. It has reviewed 34,000 cases, and it has made more than 890 referrals, about one every 2 weeks of its life, 70% of which have resulted in convictions being quashed or sentences reduced. The wrongful convictions carry absolutely enormous human cost to the defendant, injustice to the victim, a threat to society that the innocent person is in prison and the guilty person out, and they undermine public confidence in the justice system enormously. I hope that this quick run through of some of the views I've come to in the last few months and some of the important features of how we are organised will help you to design something even better for Australia. It is my view that you should have a CCRC, so I wish you good luck.